It is indeed a privilege to stand before you today to speak on the monumental journey, 75 years of the Supreme Court of India, an institution that has stood as the final guardian of our Constitution, the arbiter of justice, the protector of fundamental rights, the balancer of powers between the legislature and the executive, and the conscience keeper of Indian democracy. The Supreme Court of India is the apex judicial body under the Constitution of India. Article 124 of the Constitution states that there shall be a Supreme Court of India. The Supreme Court came into existence on 26 January 1950 with the coming into force of the Constitution. When the Supreme Court first sat in 1950, it was envisioned not just as an apex judicial body, but as a living symbol of constitutional morality and democratic ideals. In these 75 years, the court has evolved not just in its jurisprudence, but in its institutional character, its methods of functioning, and in its relationship with society. The Supreme Court of India was entrusted with wide-ranging powers, original, appellate, and advisory. But its true authority stems not just from the text of the Constitution, but from the trust reposed in it by the people of India. And now, to understand the landmark phases in constitutional jurisprudence, let us revisit some key phases and landmark judgments that demonstrate the court's transformative journey. In Menaka Gandhi versus Union of India, in the year 1978, the court adopted a broad liberal interpretation of Article 21, declaring that the right to life and liberty includes due process, fairness, and reasonableness, thereby overruling the Gopalan case. Since then, the Supreme Court has played a pivotal role in expanding the ambit of Article 21, the right to life and liberty, to include right to environment, privacy, and even dignity. The advent of public interest litigations in the 1980s revolutionized access to justice. No longer was the courtroom limited to those directly aggrieved. Any citizen with a sense of justice could knock on the court's door. In S.P. Gupta versus Union of India in the year 1981 and People's Union for Democratic Rights versus Union of India in the year 1982, the court laid the foundations for pills allowing access to justice beyond the traditional litigant model. The landmark judgment Vishaka versus State of Rajasthan in the year 1997, issued in the absence of legislation, established guidelines to prevent sexual harassment at the workplace, highlighting the court's proactive role in protecting rights. In S.R. Bommai versus Union of India in the year 1994, the court curtailed the arbitrary use of Article 356, President's Rule, reaffirming the principle of federalism. In Union of India versus Association for Democratic Reforms in the year 2002, required candidates contesting elections to disclose criminal records, assets, and liabilities. Enhancing transparency in electoral politics was laid down. More recently, in Justice K.S. Puttaswamy versus Union of India in the year 2017, the court recognized the right to privacy as a fundamental right under Article 21, paving the way for further discourse on data protection and digital rights. In Navtesh Singh Johar versus Union of India, in the year 2018, the court decriminalized consensual same-sex relationships, holding that constitutional morality must prevail over social morality. And in Indian Young Lawyers Association versus State of Kerala in the year 2018, known as the famous Sabarimala case, the court addressed gender equality in religious practices, though not without public contestation. The court has also intervened to ensure constitutional compliance from the executive, as seen in Independent Thought versus Union of India in the year 2017, where it read down marital rape exception for minor girls. It has also introspected on its own structure. The second judge's case, 1993, and the third judge's case, 1998, created the collegium system for judicial appointments, aiming to secure judicial independence, though debates about transparency and accountability continue. In SP Gupta versus Union of India, the first judge's case, the Honorable Supreme Court gave a literal meaning to the word consultation, appearing in Articles 124 and 217 of the Constitution. The court took the view that the opinion of the Honorable Chief Justice of India is merely consultative, and the final decision in the matter of appointment of judges is left in the hands of the central executive. The challenge to the executive primacy thus failed in the first judge's case. The system then in vogue and the above judgment came under severe criticism on the ground that the appointments were prone to political influence and hampered the independence of judiciary. There was demand for amendment of the Constitution to curb the primacy of the executive in the appointment of judges. In its 121st report issued in 1987, the Law Commission advocated the setting up of a judicial commission for appointment of judges. The matter was again considered by a 9-judges bench in Supreme Court Advocates on Record Association versus Union of India, popularly known as the second judge's case. In this case, the majority gave up literal interpretation and adopted a wider meaning of the provisions in Articles 124 and 217. Particularly, the word consultation was given a broad meaning. The second judge's case overruled the view in SP Gupta case by a sort of purposive interpretation resorting to the constitutional philosophy and independence of judiciary. As per the second judge's case, the opinion given by the Chief Justice of India in the consultative process has to be formed taking into account the views of the two senior-most judges of the Supreme Court and the opinion of the Chief Justice of India for the purpose of Articles 124.2 and 217.1 has primacy. In case of appointment of a Supreme Court judge, the proposal is to be initiated by the Chief Justice of India, and in the case of a High Court judge, by the Chief Justice of that High Court. In re-presidential referent case known as the third judge's case, again a 9-judges bench elaborated and clarified the second judge's case. It was held that the opinion of the Chief Justice of India has to be formed on the basis of consultation with the collegium comprising of him and the 4 senior-most Supreme Court judges, and the opinion of all members of the collegium in respect of each recommendation should be in writing. The plurality of judges in the formation of the opinion of the Chief Justice of India is emphasized as a check against the likelihood of arbitrariness or bias. Thus, by a process of judicial invention, what is called the collegium system of appointment of judges came into existence. The primacy of the executive in the appointment of judges, which was in existence prior to the Supreme Court Advocates on Record Association versus Union of India, second judge's case was under severe criticism. Supersession of Justices Jayashankar Manilal Shelat, K.S. Hegde, A.N. Grover, and the appointment of Justice A.N. Rai as the Chief Justice after the judgment in Kesavananda Bharati's case. Supersession of Justice H.R. Khanna and the appointment of Justice M.H. Beg as Chief Justice as a consequence of the dissent in the infamous habeas corpus case, arbitrary transfers of judges of the High Court during the national emergency, refusal to confirm U.R. Lalit, additional judge of the Bombay High Court, who granted bail to students during the emergency, and R.N. Agarwal, additional judge of Delhi High Court, who had ordered Kuldeep Nair to be released from preventive detention. Exclusion of eminent judges like G.P. Singh from elevation to Supreme Court were among the instances highlighted as politically motivated, revengeful, and a testimony of the drawback and danger of the executive primacy. The collegium system developed in India is a compelling model of the substantial application of the doctrine of separation of powers, which ensures that the judiciary retains control over judicial appointments. Despite its imperfections, the collegium system serves as a crucial institutional safeguard. It significantly limits interference by the executive and legislature, thereby preserving the judiciary's autonomy and insulating judges from extraneous pressures that could otherwise compromise their impartiality. There may be criticisms of the collegium system, but any solution must not come at the cost of judicial independence. Judges must be free from external control. When courts act to empower the powerless, grounded in constitutional text and moral clarity, they do not usurp democracy. They deepen it. I must highlight that the judiciary may not be the most visible arm of the state. It may not command battalions or shape budgets, but it performs a task more difficult. It keeps alive the promise of justice. In India, this task has often been thankless, occasionally triumphant, and always essential. The judicial authority is most enduring when it is exercised with a sense of humility. When the court is seen not as an omnipotent arbiter, but as a co-traveler, in the democratic journey. The judiciary is not a savior, it is a sentinel. It does not march, it watches. And when necessary, it speaks, not to please, but to preserve, grounded in constitutional values. Judicial independence and judicial accountability go hand in hand. Independence without accountability will lead to despotism. The question is never whether there should be judicial accountability, but how judicial accountability can be balanced with judicial independence. The two values should be perceived as a complementary rather than antithetical. The quality of independence allowed to the judicial branch is also posited on the premise that the person in whom it is vested will behave in an ethical manner in his judicial life. A sense of propriety is expected to accompany the assumption of office, to which independence attaches and attracts the public confidence necessary for the continuation of judicial independence. In that sense, the independence of judicial office attracts personal accountability. India's judicial history offers profound moments where this philosophical independence was both tested and asserted. The most cited instance that all of you may be well aware is the Surepalli Nanda decision, which involved a quorum of 13 judges, the largest in Indian history. In this case, the Supreme Court established the basic structure doctrine, which elucidated that while Parliament could amend the Constitution, it could not alter its fundamental identity. Principles such as the rule of law, separation of powers, and judicial review were deemed unamendable. This doctrine, unprecedented at the time, was rooted not in textual literalism, but in an ethical reading of democratic continuity. It is equally instructive to juxtapose landmark decisions such as Kesavananda Bharati with judgments like ADM Jabalpur and AK Gopalan to acknowledge that the Indian judiciary too has traversed periods of profound trial and transformation. Particularly during the emergency, the court grappled with serious challenges to its independence and at times exhibited troubling deference to executive power. Yet this phase of institutional strain gave way to a renewed judicial consciousness, ushered in by the decision in Menaka Gandhi, which marked the beginning of what we now understand as India's era of transformative constitutionalism. In this period, the Supreme Court has reaffirmed the supremacy of the Constitution and understood that its foundational values, especially those relating to life and liberty, are inviolable and beyond compromise. The Indian judiciary is vested with the power of judicial review under Articles 32 and 226 of the Constitution, empowering the Supreme Court and High Court, respectively, to examine the constitutionality of actions undertaken by all organs of the state. This includes the authority to scrutinize decisions made by the constitutional functionaries, such as the Election Commission, the Speaker of the Lok Sabha, state legislative assemblies, and the governors of states. Most notably, this jurisdiction extends to both legislative enactments and executive actions, ensuring that no act of governance is beyond the purview of judicial oversight. This expansive power of review is a cornerstone of India's constitutional democracy and a part of our basic structure, affirming that legality and constitutionality are fundamental preconditions to the exercise of public power. The Supreme Court of India on 8 April 2025 delivered a landmark decision in State of Tamil Nadu versus Governor of Tamil Nadu and another, outlining the powers and responsibilities of the governors regarding the bills presented to them by a state legislature for a decision under Article 200 of the Constitution of India. This judgment also defined the contours of the powers of the President of India under Article 201 of the Constitution. Article 201 lays down the procedure when a bill passed by state legislature is reserved by the governor for the consideration of the President of India. As per the said article, when a bill is reserved by a governor for the consideration of the President shall declare that he either assents to the bill or that he withholds assent. Below are the key findings of the Apex Court on the same. 1. President's decisions are subject to judicial review. 2. The court observed that the discharge of functions by the President under Article 201 are amenable to judicial review. It reasoned that while there is no political hue to the limited discretion conferred upon the governor, the grant of assent under Article 201 as an element of political hue by virtue of the fact that the President under Article 201 has been given the prerogative to decide whether the grant of assent in certain cases would be desirable or not. The court summarized its findings as follows. Where the bill which is under consideration is pertaining to a subject matter with respect to which primacy has been given to the union government in taking a decision, keeping in consideration the desirability of having certain uniform standards of national policy, then the limited grounds of judicial review would be based on arbitrariness mala fides. President has no absolute or pocket veto and should take decision in 3 months. The bench underlined that there is no absolute or pocket veto with the president when it comes to his function under Article 201, and he or her has to choose between the two options available, either grant assent or withhold it. The Supreme Court made it clear that in cases where a bill has been reserved because it involves questions of constitutional validity, the executive should not assume the role of the courts in determining the virus of a bill and should, as a matter of practice, refer such question to the Supreme Court under Article 143. There exists a rich tapestry of such instances where the Supreme Court of India has stimulated far-reaching structural change through its interpretive and remedial powers. In doing so, the court has addressed a wide spectrum of socio-economic and human rights concerns, ranging from child labor and bonded labor to environmental degradation and the protection of women's rights. In Vishaka versus State of Rajasthan, faced with legislative vacuum, the court proactively laid down binding guidelines to address sexual harassment in the workplace, thereby affirming the right to a dignified working environment long before statutory recognition through the 2013 legislation. In Bandhu Mukti Morcha, the court intervened to liberate bonded laborers, emphasizing the constitutional mandate against exploitation. In Olga Tellis versus Bombay Municipal Corporation, it expanded the ambit of Article 21 by holding that the right to livelihood was inseparable from the right to life itself. These cases exemplify the judiciary's transformative potential when animated by a vision of justice that seeks to make constitutional promises real for those most in need of them. In the landmark privacy judgment in Justice K.S. Puttaswamy versus Union of India, the Supreme Court referenced similar decisions like Griswold versus Connecticut from the United States and rulings of the European Court of Human Rights. This engagement with foreign jurisprudence is not incidental. It reflects the universalist ethos of the Indian Constitution, a document conceived at the intersection of Western liberal constitutionalism, Eastern philosophical traditions, and anti-colonial emancipatory thought. Yet, transnational dialogue and citation must be done with care. It must not be mimicry, it must be contextual translation. What works in Pretoria may not work in Patna. What persuades in Washington must still be interpreted in Delhi. At its best, comparative constitutionalism is about mutual enrichment, where courts learn from each other's reasoning, borrow where appropriate, and resist where necessary. As we reflect on the Supreme Court's 75-year journey, we must recognize that law is not static. The Constitution is a living document, and the judiciary is its most vital interpreter. Let us remember that democracy is not a gift to be received. It is a discipline to be practiced. And in that discipline, the judiciary is a quiet guardian. The future of the Supreme Court lies in deepening constitutional values, enhancing institutional trust, ensuring judicial accountability, and working for justice, which is not only done, but seen to be done. Let me close with the words of Rabindranath Tagore, who imagined a future India in his immortal prayer, where the mind is without fear and the head is held high, where knowledge is free, where the world has not been broken up into fragments by narrow domestic walls. Into that heaven of freedom, my Father, let my country awake. Thank you.